for the question of possible UK complicity remains under active investigation.
Mark Urban there. Well, as we've heard, a senior Obama administration official has suggested that the disclosure of the information would complicate the intelligence sharing relationship with the UK. When I discussed this with the Foreign Secretary David Miliband, I put it to him that the Lord Chief Justice said something quite different, that the judgment should not be seen as devaluing the confidentiality principle underpinning the sharing of intelligence. So, was the Lord Chief Justice wrong?
No, that's a very important point. The critical thing about the judgment today is it defends the so-called control principle. That's the principle that says that it's not for one country to disclose the intelligence of another country because it would undermine the trust that is the essential basis of intelligence sharing. However, the court found that because an American court had referred to some of the unacceptable practices that had taken place, it was therefore right for the English court to order the release, and I accepted that today.
But then why would the Americans be at all disappointed? If it had already come out in an American court, why shouldn't it come out here?
Well, the American court didn't publish the disputed 7 paragraphs which summarise the unacceptable practices. It didn't publish them per se, it referred to them. The disappointment is the absolute nature of this principle, this control principle that says that American secrets are American secrets and British secrets are British secrets, and it's important that countries control their own intelligence even when they share it with other countries. I said in the House of Commons today that we would be working very closely with the Americans and with others who have also been following this case to try and explain that the court had reaffirmed the importance of the control principle and try to minimise any risk to the sort of intelligence sharing that even recently we've seen is so important for our national security, for the safety of all of us.
Right, but you can understand that almost everybody watching this will think that what has happened here is the British government tried to cover up something because it was fundamentally embarrassing that the British government was in some way complicit in the torture of someone who had been a British resident.
Well, I'm glad to have the opportunity to address that because it's completely untrue. First of all, we were at the forefront of ensuring that Mr Mohamed and his defence counsel had access to these documents so that he could defend himself and get out of Guantanamo Bay, which we succeeded in doing. Secondly, in respect of the alleged wrongdoing associated with the British government, this is being tested in the courts at the moment, and we are not just cooperating with that fully. It was the Attorney General who has referred the matter to the police to see if there is a reason to press charges. So that's being addressed. Thirdly, we always said that we had no objection to the content of the material being published, but it had to be published by the Americans because it was their information.
But a lawyer acting for you, Jonathan Sumption QC, also protested over a judge's what was called exceptionally damaging criticism of the British security services. Again, it looks as if judges were being leaned on to make sure that all the details of this case didn't come out and that showed that the British intelligence service in a very poor light.
Well, that's also untrue. The 3 judges concerned are almost the most senior judges in Britain, the Lord Chief Justice, the Master of the Rolls, the President of the Queen's Bench Division. They issued a draft judgment last Friday to all the key parties in the case and invited comments. And out of the 295 paragraphs, the counsel for the government queried one of them and queried whether or not it was actually based on the evidence that had been presented to them and was an accurate representation of that. The judges considered his representation, they met, they discussed it between the 3 of them, and they decided it wasn't an accurate representation of the evidence that had been submitted to them, and so they redrafted it. That's normal court practice, and it's about being accurate and evidence-based in the approach.
Well, there are other lawyers, as you know, who say this wasn't normal because they weren't fully informed of all this. But isn't the key point here that what we're talking about is a culture of not respecting human rights within the security service? And that was in the original draft.
No, I don't think that's appropriate. There is no truth in the suggestion that we are complicit or cooperate in the outsourcing of inhuman treatment. There is no truth in the suggestion that the security services operate without independent oversight. The courts, to take one example, have shown that today. And there is no truth in the suggestion either that if wrongdoing is found, it is swept under the carpet. It is actually exposed to investigation by the Attorney General and eventually by the police if merited.
Do you, as we sum this up, do you personally have some remorse or regret over the way this person was treated?
Of course his treatment was completely unacceptable. He was a British resident who ended up in Guantanamo Bay. It's clear that there were practices that were unacceptable to us to which he was subjected. That we worked very hard to get him out of Guantanamo Bay on the basis of the release of the documents by the Americans. Our position on this is absolutely clear, that anything that constitutes inhuman treatment, never mind torture, is completely unacceptable.
And a final thought, it's not just British Muslims who'll be annoyed about this, but do you accept that some young British Muslims will feel particularly outraged and alienated by this?
Well, I think all of us who are decent, good British citizens, whatever our age or our religion or our position either as broadcasters or government ministers or members of the public, never want to see cruel and inhuman treatment that contravenes the legal obligations or the morality of this country. And what people have to remember is this was not done by British people. It was done to a British resident or a former
But allegedly with
resident.
British complicity, that's the point.
Well, there's one particular issue involving a particular part of the case which our system, because when it sees wrongdoing, investigates it, is currently having investigations by the police force. That's the right way of doing it, because we have high standards. We seek every day to uphold those high standards. If there's serious evidence that they have not been upheld, then a proper investigation takes place, an independent investigation, and if charges are merited, then they are brought.
Foreign Secretary, thank you very much.
Thank you very much.